To prove retaliation, you have to show that you engaged in protected activity and that your employer took an adverse action against you. The most important piece of evidence in your retaliation case is what courts like to call proximity in time. Don't worry, I'm going to explain that and everything else in this video, so stick around. Now, nothing in this video is legal advice. This is a YouTube video, and I don't know anything about the specifics of your case. But if you think you suffered illegal retaliation in Washington State, feel free to reach out to my firm. The link to my website is in the description below. Before we talk about how to prove your claim of workplace retaliation, we need to touch on what it is that you need to prove in the first place. To succeed in a claim of workplace retaliation, the worker must prove that their employer took an adverse action against them because of their protected activity. So you're going to have three things to prove. First, that you engaged in protected activity. Second, that your employer took an adverse action against you. And third, that your employer's adverse action was motivated by your protected activity. So let's start with protected activity. Protected activity includes the following, but this is not an exhaustive list. Reporting discrimination, reporting harassment on the basis of your protected characteristics, reporting unsafe working conditions, reporting any illegal activity, reporting a violation of wage laws, or asking for a reasonable accommodation, just to name a few. And here are some things that are not protected activity. Reporting that your manager is rude or abrasive or mean. Reporting bullying that's not based on your protected characteristics. Reporting unrealistic work expectations. Reporting inadequate support from your managers or your coworkers. Generally, for the activity to be protected, it has to be reporting discrimination, harassment, or something else that implicates your legally protected rights in some way. And this first element is easy. Either you engaged in protected activity or you didn't. And when you engage in protected activity, do it in writing because it creates a record. The second element that you'll have to prove in your retaliation case is that your employer took an adverse action against you. The most clear adverse action is termination. And most of the time, you will need to show that you were actually terminated in order to have a case of retaliation. Sometimes other adverse actions also work, like demotion, a negative performance review, or a failure to promote. But it will depend on the kind of retaliation case you're bringing. And most of the time, you will need to show that you were actually terminated. But proving you were terminated is easy. Either your employer terminated you or it didn't. Finally, you will need to show that your employer was motivated by your protected activity when it took that adverse action. And this is where things get tricky. How are you going to prove your employer's motivations? Well, that's what we'll focus on for the rest of this video. Okay, so now that we know what to prove, the question is how will we prove it? And the answer is simple, with evidence. There are a couple of pieces of evidence that we will use, but one piece of evidence in retaliation cases is more important than any other. And courts call this piece of evidence proximity in time. Proximity in time means how soon after you engaged in that protected activity did your employer terminate you. The closer in time, the stronger the evidence of retaliation. For instance, imagine a worker reported to HR what she believed was gender-based harassment, and then the employer terminated her 24 hours later. Well, that's a very close proximity in time. And if the proximity in time is close, it will help establish to the court that your employer was motivated by your protected activity. On the other hand, imagine that a worker engaged in protected activity, but kept her job for another 3 years until the employer finally terminated her. Well, even if the employer was motivated by her protected activity, the proximity in time is so remote that she would need to find other ways to prove her claim. Next is direct evidence. Direct evidence is evidence directly related to your employer's motivation. Like if your employer sent you an email that stated it's terminating you because of your protected activity. Well, in that case, the employer just told you his motivation. So now that email is direct evidence of his motivation. But as I'm sure you can guess, direct evidence is pretty rare in retaliation cases because employers know not to incriminate themselves. But if you have any direct evidence, it will certainly help establish your case. Finally, we will use circumstantial evidence. And circumstantial evidence is evidence of the surrounding circumstances that would lead a jury to conclude that the employer was probably motivated by your protected activity. And probably is all you need to prove your case in a civil lawsuit. It's not like a criminal case where you need to prove beyond a reasonable doubt. In civil cases, you only need to show that it probably happened. Circumstantial evidence that can help you would include the following. First, performance reviews and discipline history. For instance, if your employer's stated reason for terminating you was poor performance or insubordination, yet you've never been written up for poor performance or insubordination, then it's more likely that the real reason for your termination was not poor performance or insubordination. Next is comparator evidence. Comparator evidence is any evidence that your employer treated you differently than it treated other employees. So for instance, if the employer's stated reason for terminating you was tardiness, yet the employer has never terminated anyone else ever for being tardy, then it's more likely that your employer's real motivation was your protected activity and not your tardiness. Finally, any evidence that your employer is lying. At the end of the day, we are trying to prove that your employer is lying, that its stated reason for terminating you is false, and that its real motivation was your protected activity. So any evidence that you have, like inconsistent statements about your termination or even flat out lies, will help you prove your case. So there you go. Now you know how to prove a case of retaliation. The most important piece of evidence will be the proximity in time between your protected activity and your termination. But other evidence is also helpful, such as statements concerning your employer's motivation or any circumstantial evidence that your employer is lying. If you think you were illegally retaliated against in Washington state, feel free to reach out to my firm. And if you found this video helpful, hit the like button and subscribe to my channel. It helps other workers find this video. And the more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.